practical suggestions, well, actually, both for employers, and I'm going to ask you also for employees. So let's start with employers. Do you have any suggestions for them?
Yeah, I think I mean lots of suggestions for
Okay.
both. I think on the employer side,
Yeah.
the first thing is it's a good time to review your employment agreements,
Okay.
right? It's basically always a good time to do that, but now especially. So if
Mm-hmm.
you have a contract that does not align with the new sort of wording and the new standards,
Mm-hmm.
there is a risk that the contract will be invalidated. And if the contract is invalidated, as I said, it just comes down to basically the court decision and
Mm-hmm.
factors which are called the Bardell factors.
Mm-hmm.
Those factors basically look at the age of the employee, the length of service, the type of position that they had, how likely is it that they'll find similar jobs. So it's really looking at, what is the totality of the relationship?
Mm-hmm.
And what the court is saying in that analysis um, is it basically easy for the employee to find the same job when it comes down to it at the end of the day, right?
Yeah.
You have, a young lawyer like myself, who, if I'm fired from one firm, with a
Mm-hmm.
relatively easy path can find, new employment, right? At a, another law firm I have experience and I'm relatively young and, my salary is not so astronomical that I couldn't find it elsewhere.
Mm-hmm.
But the court will likewise say, if you're in a niche role or you're older or you can't find similar employment, they'll say those lean the other way, right? That leans towards more termination pay.
Mm-hmm.
So to an employer, it's not fatal. Right? That's why I want to kind of get across. Like, even if the contract is not valid in itself, it doesn't necessarily mean you're going to be paying out millions of dollars. It just means it's a little more up in the air. You're going to have to just
Mm-hmm.
look at the factors and decide, here's what I think is reasonable, based on the situations of this case. So I would first look at your employment agreements and say, okay, do I need to make some updates?
Mm-hmm.
The other thing to keep in mind is updates are not as simple as just giving your employee a new contract. In the same way, you couldn't go to your employee's earning 100,000 a year. You can present them a contract that says $10,000 a year and say, hey, sorry, you got to sign this. We all know intuitively
Yeah.
there'd be something wrong there.
Yeah.
But really, it's the same with a termination clause. Because if I have a termination clause now that says
Yeah.
I can get a month per year, 2 months per year, whatever it is. And then I'm signing a new agreement that says I can only get a week per year. I'm effectively accepting a lot less money. So I'm effectively accepting a worse contract.
Yes.
So when employers are bringing in these new contracts, you really have to keep in mind the exchange with the employee. And legal terms called consideration.
Mm-hmm.
But really, what it means is that if you're asking something from the employee, there has to be some give and take, right? It has to go both ways. And that could mean a raise, that could mean an incentive. I don't
Interesting.
want to go into too much because it's a whole other video about how consideration and contracts works and all that. As you know, we can film it another time.
Right.
But for now, for
Yeah.
now, for employers, just keep in mind, as with any clause in a contract, you can't just go to your employee and say, hey, here's a worse contract. Tough luck for you. You got to sign it. There are certain processes you got to follow. When it comes down to it, probably consulting legal resources or speaking to a lawyer is going to be the best option before those updates get
Mm-hmm.
in place.
Mm-hmm.
But as I said before, if you're looking at your contract and it's not valid and you're in that intervening few months before you do the update, okay, it doesn't mean you need to shut the business down. It just means that any termination, this needs to be addressed on a case by case basis, right? And
Interesting.
you need to sort of strategize for it accordingly.
Yeah.
So those are the main things I would say for employers. Review
Okay.
your agreements now,
Mhm.
update them following the proper procedures, right? When the time comes or when you're ready.
Mhm.
On the employee side,
Yes.
I think the first thing to look at is do not just sign on the dotted line if you're fired. Right? Go get legal advice. This was always the case, but now more than ever, so many contracts are invalid that you really could be leaving thousands of dollars on the table. And I want to be very clear. I don't do a lot of employee termination stuff. There's a lot of like the lawyer pitches online and on the bus ads and stuff, and there's nothing wrong with that. But I just want to be clear when I'm saying this. Like, it's not an opportunity for the lawyers, right? It's very much for the individual, for the employee. Do it without a lawyer if you don't trust lawyers, but don't leave that money on the table. I always worry that it comes across as like, like a sales pitch, right? But it really is true now that, so many contracts are invalid. If your contract says a week per year and you've been there 10 years, you may be leaving, right? If you take that 10 weeks as your total pay, you could really be leaving tens of thousands of dollars, like a substantial amount of money on the table. So, however you want to pursue that independently with a lawyer, with someone on contingency, paying hourly rate, whatever it is, I would
Mhm.
just say before you sign, if you're terminated, get the advice, right? Go to the resources, look online, uh, take advantage of lawyers that offer the free consult. Uh, Sorry to all my fellow lawyers, but I think sorry if you're putting it online, make good on that for the people, right? If you see an employment law firm says, "Hey, we'll speak to you about your case," do it. Get 2, 3 opinions. Myself, like my firm, will do a free initial consult, so you can bug me as well. It's no problem. But I really think it's so important. Like, take that week, and if the employer is saying you don't have time, tell them they have to make time. Obviously, don't ever put yourself in an unsafe situation. If the employer is saying, I'm barricading the door and you can't leave till you sign this, okay, yeah. And hey, those things happen, right? You get some pretty wild situations. So, if you're in a situation where you absolutely must sign the document, okay, put your health and safety first. But other than that, take the time. Even if your employer says you don't have time, legally you do. You have a right to get independent legal advice, have that termination letter reviewed. And in that review, you might find that there's, a lot of money that's being left on the table, or that your contract is invalid or something like that. So that's my main piece for employees, right? Just, you know, your employer, it's not anything nefarious. It's not that they're doing anything wrong, but they likely are not the best positioned to tell you your rights. Right? They're just not. They're not employment
Right.
lawyers. They're not judges.
Yeah.
Even if they think and have the very best intentions in saying, here's your termination letter, we're offering you 5 months, and that's the most reasonable offer you'll get. I'm sorry, they're not the authority to make that
I
determination.
see.
You need to take that letter, go get advice. Or I shouldn't say need, but you should, take that, go get independent advice, 2, 3, 4 opinions, and then go back to the employer and say, hey, this is what I've determined, right, based on the information that I found. So that's what I would say. Just like take that extra step, take that extra day, right? That extra time to go through it and really make sure that 100% before you sign, this is the best offer I'm going to get, or
I
for
see.
whatever reason, strategically, this makes sense for me.
And this is incredible because I'm just gonna speak off because I'll probably edit this out because I didn't think that you're in a position to even negotiate with your employer who's letting you go. I just thought when you're fired, like when you're terminated, they give you this letter and that's all you're gonna get. And if
I
you want
know.
to object, then you go to court. Like I just got okay, I do have a question. Actually, okay, so let's say
I just want to quickly say, like, so many people that I
assume that,
always
right?
try to say in presentations as well, like when I do the in-person presentations, I always try and push on people. Like, it's like something that's just permeated the culture, right? I thought that too. Like, I had a job as a teenager and
Yeah,
I had, not good
yeah,
experience at.
yeah.
I had no idea at the time that you could go take your termination letter and get it reviewed. And now I'm like, oh, I wish I had it because
That's
the
so
circumstances were not
okay.
quite legit from the employer. But yeah, it's a
Yeah.
very, very common belief. And, I always try and tell people, like, take that time. And it's not always going to work, right? Like, sometimes you take the day and the employment lawyer tells you, look, like, this is a tough case. It's going to cost
Mhm.
50,000 to go through the litigation.
Yeah,
Maybe you have an offer of $10,000 on the table.
yeah,
Maybe that's good enough, right?
yeah,
Even if you are leaving some money. So
yeah.
it's not to say like, the employer hands you the termination letter, shred it up in front of them, and say, "I'll see you in court." that's rarely the answer, right? But it is totally appropriate to say, thank you.
Yeah,
I'd like to get this reviewed.
I
I'll
see.
get back to you. Please allow me 5 days to, to look at it. And I can tell you as a lawyer,
Yeah,
when I've had employees reach out and I
yeah,
reach out to the employer
yeah.
and I say, hey, I'm in the process of being retained. I need an extra week, whatever it is, right? I have other files going on, whatever's happening. It's never an issue. Employers
Oh,
don't want, like, it doesn't look good on the employer
right,
to be saying to an employee's lawyer, like, no, sign it tomorrow and get back to me, right? Like,
right, right.
the employer doesn't want that situation either where the employee was signing in a rush. So,
Yes.
for the employees, like, if your termination letter says sign this within 5 days or whatever, go ask for help, go get the advice. And I can tell you just from my experience, it's never been a problem to get an extra week or two, right? If the employee
Right.
needs it just to go through things and make sure they're like really thorough on things. I think it's, you're in the termination meeting and it feels like
Yeah.
everything's really rushed,
Yeah.
but really once that initial pressure kind of deflates,
Yeah.
the employers are also looking for the most part to do things properly, especially once they're hearing from a lawyer. They're not looking to rush
Okay.
you or to start more of a fight with the lawyers, right? Usually it's just, can I have 5 days to review this? Can I have 10 days to review this? No problem, let us know. And even at the end of that period, if I come back and say, hey, we want a little more, I don't think I've ever had a situation where the employer's just said offers off the table.
Oh,
It's
wow.
always like there's at the very least, they're saying we're sticking to our offer
Right.
or they're willing to negotiate. But, that's all just to say to the employee, don't be afraid. Theoretically, it could happen that the employer could revert their offer, but that would be very, very rare and exceptional circumstances. Because again, the employer has liability too, right? And things like rushing an employee, pulling away an
Mm-hmm.
offer,
Mm-hmm.
those don't look good. And the employer's also thinking like, hey, this employee might sue me. And if
That
that
could always
happens,
happen. Oh,
yeah,
I've got a
exactly.
question.
So the
Right.
employer's
Yeah.
also thinking that, right? So,
Yeah.
they're keeping that in mind too.
Yeah. What happens if you sign the termination letter? Does that mean it's hopeless? Like, I mean, that's it. You cannot come
It's going to
back.
be it's going to be very like circumstantial at that point.
Oh, wow.
There are
Okay.
cases where, so the example I gave before, the employer is standing in front of the door. They say, you're not allowed to leave until you sign this.
Yeah.
That agreement's not valid. Oh,
Right.
sorry, I guess nothing in law is 100%, but 99.9%, no court would uphold that agreement. You
Yeah.
get out of the room, you call the police, you call a lawyer, right? You say like that's forcible confinement, like that's getting into criminal
Right.
activity.
Okay.
When those
Yeah.
type of things are at play, no document signed is going to be upheld by any court, right? Though there's concepts such as duress, things
Yes.
have to be signed
Yeah.
voluntarily. So those extreme situations, the employer's threatening you, they're holding you there. Um, those are fairly certain the agreement's not going to be upheld. Other than that,
Yeah.
unfortunately, from what I've seen, I've actually not been too much in the employment context with this, but I have done a couple contract litigations, so like
Yeah.
service agreements, those type of things.
Yeah.
The court does tend to kind of say, like, if you're an adult, if you're given time to review the contract, if you're, a responsible individual with capacity and there's no sort of issues there, it's going to pretty much be assumed that you signed voluntarily. Like you're going
Mm,
to, as the employee, you're going to have to bring forward some pretty good grounds for, why this wasn't, right? If you
yeah.
just say like, hey, I signed this, but, I didn't really think about it enough,
Yeah.
court's not going to, it's probably not going to fly,
Interesting.
right? The court's generally going to say, look, you're all responsible adults. I'm sorry you didn't think about it enough, but because otherwise the courts would just be invalidating every contract, right?
That's right.
Because
A contract has to,
everyone,
yeah.
yeah, everyone who was upset would just say, "Oh, I didn't realize this," right?
Yeah.
So other than the extreme
Mm,
cases,
hmm.
it is possible, but there's gonna have to be some pretty like
Mm,
you're going to need some meat on the bones, right? So, maybe a situation such as there's been like a history of discrimination, right? You're in like a racist place, so maybe in that particular meeting there wasn't an instance of discrimination, but you're feeling, scared and sort of unable to make decisions without duress because of that
Mm-hmm.
very serious history of human rights violations. So,
Mm-hmm.
there can be cases like that, but you would really have to look at, what exactly happened to you, right? And try and sort it out from there.
Like you said, just be careful. Like, just don't sign in a rush. And
I
yeah,
think the best is, if you have any option to
yeah,
say, I'm taking this with
okay,
me,
yeah.
that's the best. And again, like the caveat just being to put yourself in a bad situation, right? But if you can take it and give it a day or two at least before signing, I think that's always preferable.
Well, thank you so much, Sam, for the all this information today. Wow, this is incredible. And you will be back with us again sh shortly. I think in the new year, because I think you said that something interesting is happening on sort of the non-compete clauses. That you said that there's some recent legislation that actually prevents people from putting that in. I'm very curious about that.
I know you were listening through this thinking, there hasn't been enough change in employment law recently. Employment law is very boring. I'm
My
kidding.
bad.
Yeah, so yeah, for everyone watching, feeling overwhelmed and like this is
Yeah.
way too much. There's a whole other layer of changes that have happened. Fortunately, I think the legislation is a little clearer. The government has been a little more clear about,
Mhm.
these are the rules.
Yeah.
Whereas Waksdale, like any good court decision,
Yeah.
always leads to interpretation questions, right?
Right.
And thinking
Right.
about it. So
Right.
I look forward to getting into that one too. But yeah, it's been an interesting run for employment law, which tends to generally be a pretty active area of law. So
Really?
it's
Okay.
living up to the hype, right? If it's not the minimum wage changing every
Yeah.
year,
Oh, yeah.
it's termination clauses and
Yeah.
non-competes, and
It's
there's always something.
well, I'm really looking forward to that. So thank you so much,
Me
Sam,
too, me
for
too.
being here today. And thanks everyone for
My
watching.
pleasure.
Just a very quick reminder. I have finally made myself sit down to do a full directory of the videos that we have on this channel. So you can just use the link that I have in the description box, or just kind of, I'm going to put in a little card up here, the I button, we click there, it will take you to the place where you can get yourself a free copy, of course, a free download of the a full set of videos that I have, and it actually includes videos that are in production. So yeah, so you can get a little preview of sort of what's coming up next. And yeah, so thanks to everyone for watching. And if you like this video, you find it's helpful, give us a little like and share it with your friends. And we'll see you the next time. Thank you and bye bye.